Most people think that if you're defending yourself, the charges just disappear. Unfortunately, that's not how it works in Texas. Self-defense is real and it can protect you, but it's not automatic. You must demonstrate to the court that your actions were justified, and then the state must attempt to disprove that. In most cases, the difference between freedom and conviction comes down to the evidence. My name is Joseph Ruiz. I'm a criminal defense lawyer here in Houston, and I work with people who never asked to be in a fight, who never wanted trouble, but who suddenly find themselves arrested and accused of a crime when all they did was try to stay safe. Today, I want to walk you through how self-defense works in Texas, what a jury is going to want to see, and how the right evidence can completely change the outcome of a case. If you or someone you know is facing charges where self-defense applies, don't wait. These cases move fast, and the sooner we can start building the story of what really happened, the better your chances. In Texas, the law says you can use force if you reasonably believe you or someone else is in danger. And when I say danger, I mean immediate danger, not something that might happen tomorrow, not a vague threat. The law also says the force you use has to make sense compared to the threat you're facing. If someone pushes you in an argument and you respond by pulling out a firearm, that's probably not going to fly unless you can show you genuinely believed your life was on the line. If someone charges at you with a knife and you pull out a weapon to stop them, that's a much stronger claim. Texas also has what's called the Castle Doctrine. That means if someone comes into your home or even into your car or workplace, the law does not expect you to run away. You have the right to defend yourself where you are. Now, here's the part that surprises a lot of people. When we raise self-defense in court, the burden shifts. First, the defense has to put forward some evidence that you acted in self-defense. It doesn't have to be overwhelming, just enough to raise the issue. Once that happens, the burden slips back to the prosecution. Now it's their job to prove beyond a reasonable doubt that you are not acting in self-defense. And that's where the fight usually comes down to the quality of the evidence and ultimately the credibility of the witnesses. So what kind of evidence makes a difference? Sometimes it's witnesses, people who were there and can back up what really happened. Sometimes it's medical records that show you were hurt and didn't start the fight. Video footage from a store camera or even bystanders' phones can completely turn a case around. And then of course there's your own testimony, telling the court what you saw, what you felt, and why you believed you were in danger. When all those pieces line up, it makes it very hard for the prosecution to convince a jury otherwise. Again, if the jury has a reasonable doubt about whether it was or was not justifiable self-defense, they must find you not guilty. Let me give you an example because this is where the law really meets real life. We recently handled a case where my client was charged with aggravated assault with a deadly weapon after pulling a gun on someone on a golf course. My client and his golfing group got into an argument with another group on the golf course. One of the guys in the other group had been drinking quite a bit and angrily marched in the direction of my client's group, wielding a golf club as though he were going to attack them with it. My client, who had a concealed handgun license, reacted and pulled a handgun for the purpose of keeping him at bay. No shots were fired, but he did threaten them if they came any closer. We convinced the grand jury to no-bill the case based on the little used threats as justifiable force defense. Basically, it says you're allowed to threaten death or serious bodily injury if the purpose is to ward off a would-be attack. You don't have to wait and see what the other person is capable of before taking action. Here's another story just to show you how it all comes together. I had a client once charged with aggravated assault after a fight at a gas station. The police showed up, saw one man bleeding, and immediately assumed my client was the aggressor. On paper, it looked bad, but once we pulled surveillance video, it showed that the other man charged at him first. Witnesses at the scene said the same thing, and the medical record showed my client had defensive injuries, not offensive ones. So here's the bottom line. You need to show why you believed you were in danger, that the threat was real and immediate, and that the way you responded made sense under the circumstances. So if you've been charged here in Houston and you know you were only protecting yourself, don't wait and hope it will work itself out. Get someone in your corner who understands these laws, knows how to build your defense the right way, and knows how to get your narrative out to the grand jury, the DA, or the jury, depending on how far the case goes. I'm Joseph Ruiz, and if your freedom is on the line, I'm here to fight for you.